Okay, let's see. Patrick, can you hear me?
I can, yes.
Okay, there we go. Let me get myself straight. I think I hit a wrong button. Okay, so we're going now. Yep, we're going. So good to be here. Let me do one thing here. Okay, we're good. Um, Thanks for your patience, guys, out there if you're watching live. A lot to go over in a short period of time, so we're going to jump right in. Excited to have a colleague of mine, Patrick Cawley, state planning attorney in Pennsylvania. Patrick, why don't you kick it off with just a little bit about your background and maybe why you became an estate planning attorney and do what you do?
Sure. And it was a bit of a winding road from law school to an estate planning practice. I was very much a traditional courtroom lawyer for the first decade of my career. But that took me then to the state legislature, where I ended up just writing the law of estate planning for Pennsylvania. We rewrote the power of attorney law. We talked about a lot of work on how do you make medical decisions for a person who's incapacitated? What about financial exploitation of older people? And so eventually, politics being what it is, I was ready to move on from there, and I couldn't wait to represent people going through the challenges I had been working on.
Great. Well, fantastic. So I'd like to add to that a little bit. What caught my attention was drafting and writing legislation on power of attorney law because power of attorney seems simple enough. You give somebody power of attorney. If they need to use it, they take it to your bank, your brokerage firm, sell your house, easy enough. But in reality, it's often not that simple. Some states have created statutory powers of attorney. Some states due to third parties not honoring powers of attorney, they've created legislation where third parties have to put in writing why they're rejecting a power of attorney. So, what's that whole power of attorney situation look like in Pennsylvania?
Yeah, that's really the rub, isn't it? It's you want it to be honored. You're doing this for a seamless incapacity plan, but who's on the front lines of this? It's the financial institutions, it's the insurance companies. And just earlier today, I was on a call with a number of Pennsylvania estate planning attorneys about another round of legislation with this tension between the financial institutions and the people trying to use the power of attorney. In a sense, we're on the same page because we don't want the bank being a party to financial exploitation of an incapacitated person. They don't want to be involved in that. They want to be on the front lines and protect their account holders. But we also want, if dad is incapacitated and son has the power of attorney, we want that to go smoothly and the business goes on. So we do not have a statutory power of attorney, meaning it's just a form. There's a little more room for creativity and to be very specific about what someone can do for you if you're incapacitated. But and then with that variety, I suppose it puts the financial institutions in the position of wondering, is it valid?
Right. They have to scrutinize it a little bit more. It's kind of that's how we are is every power of attorney that gets presented to a financial institution around here in Louisiana, everyone's unique because each attorney has kind of created their own way of doing a power of attorney. So that's the downside of not having that consistent kind of statutory form. I'm curious though, on a call today with a bunch of estate planning attorneys, what else did you guys discuss without revealing any confidences other than kind of dealing with financial institutions? What's up on everybody's mind?
Oh, we have a lengthy list of legislation that's pending that we get together once a month and we talk about. And because the legislature wants to hear from us, just like they want to hear from the bankers. Back when I was the executive director of the committee that works on these things, I would call in the bankers, I would call in the lawyers, I would call in anybody who had an interest. So we're going over everything from that was the big one. We're trying to do more with elder abuse. And so, of course, most states, including Pennsylvania, have a law that says, and this is obvious, if you commit homicide, you can't then financially, be the heir of the person's estate. Well, we want to extend that to people who have been abusive, whether financially or physically. That's a tough issue to get exactly right. Boy, there's some issues more in the realm of elder law, but the nuts and bolts of what assets are countable and how much money can a person keep. There's some people might hear about a law in most states where nursing homes can go after adult children for the bill for the parent, and that gets to be an emotionally charged issue, and we want to fine tune that a little bit. So there's kind of a long list that we stay on top of, and nothing seems to be moving all that well anyway in the state legislature. So we're ready when it does.
Yeah, fantastic that there's a resource of estate planning attorneys who can give their guidance to the legislature on those issues. Great. Well, I want to come back to the elder law, Medicaid issues in a moment. I want to hit that really hard. It's an interesting topic, but I feel like I want to let our audience know just what are some of those unique aspects of estate planning when it comes to Pennsylvania law. I know the little bit that I know about Pennsylvania. I know Pennsylvania has an inheritance tax and got to be one of the only states, one of the few states in the country that has that. So, what are the circumstances around the inheritance tax, and is it enough that causes people to take action in an attempt to avoid it? What's that scenario look like?
Yes. So you're right. We are one of 6 states that has an inheritance tax. And other states will call it something different. They'll call it an estate tax. It's some
Right.
form of death tax, money leaving your estate going to heirs. And so on that transfer, does the government take money out of it in the form of a tax? The difference with an inheritance tax is the percentage of tax depends on who's getting it. So this is terribly unfair, in my opinion, that if you leave your investment accounts, your bank accounts, your house to a child or a grandchild, 4.5% of the value goes to the state in tax. But what if you can't have children or choose not to have children? Well, now if you're leaving money to or property to your siblings, it goes up to 12%. If you leave it to
Right.
nieces and nephews, it goes up to 15%. So
Wow. Okay.
so yes, to answer the second part of your question, that does bother people enough so that what they'll do is if they're one of their larger assets, they know going into their estate is going to be, let's say, their home, they'll take action and deed their house over for $1 to the adult children and go on living there. Why? Because if they live for 1 year, it's not in their estate, so there's no inheritance tax. I think that's a terrible idea to do that. There's a better way because they're giving up control, which leads to problems. I have stories I could tell you there that it leads to capital gains tax, which is much higher than 4.5% if the child then sells it.
Right.
It could cause problems in the long-term care planning. So yes, it does cause people to take action.
Is there a Pennsylvania gift tax or just the inheritance tax?
That's the thing. We don't have a gift tax. So
Okay.
if you're thinking about giving some money to the kids, or should you wait for them to inherit it? Well, why wouldn't you give it away during your life? Because the very same money will be taxed when you're gone. So,
Yeah,
but
that's that whole tax dilemma of do I give the asset away while I'm alive to avoid inheritance tax or estate tax, or do I keep it in my estate to preserve the step up in basis?
right.
So if for states that don't have an estate or inheritance tax, a lot of elderly people they want to take some action because they think taking action avoids estate tax. But if somebody's sitting on a $4 million estate and we know there's not going to be estate tax, and the advice usually is, well, just keep it all in your estate. And if it's in your taxable estate when you die, there's no estate tax, and your heirs get the benefit of the step up in basis. So I think a lot of people kind of they want to take action, and they think transferring assets to the next generation is the wise thing to do, but sometimes it's just not. So yeah, we have a kind of a confusing situation with a lot of parts between the inheritance tax, the estate tax, the capital gains tax, the step up, the carryover basis. A lot goes into it, and but I love that. I'm kind of a math guy, and I love kind of going through that with people. So you seeing some of the same thing there?
Absolutely. And I mean, it really just depends on what are you talking about transferring to the kids? Is it something that will get more valuable over time, like stocks or real estate,
Right.
and therefore then the step up in basis is an issue? I focus a lot on the control aspect. I mean, just not long ago, a family, mom and dad transferred their house to the son for, I guess, avoiding his inheritance tax in Pennsylvania. Dad eventually dies. Mom is lonely, she meets a gentleman, wants to marry this guy, and the son who owns her house says, "Mom, if you marry this guy, you're out of the house. I'm selling it." So what does she do? She lost control. So I wish the worst capital gains tax on that son, but that's not very charitable because grief and money it does things to people.
Yeah. Yeah. So, all right. So I want to hit a couple of other issues. I'm always interested to hear what the probate scenario is in different states. Some states, it's not that difficult. We just do the filings. There's no court hearings. There's no required delay. It's relatively harmless. Other estates, and I hear a lot from the West Coast in California, how awful the probate is in California, how long it takes and how expensive it is. Where do you stand in Pennsylvania? What's that probate situation look like?
Probably more the former. Certainly, if you Google, about probate, and you're going to see a lot of articles leading you to believe that probate should be avoided at all costs. But I think you're right to differentiate every state the way you have, because if you're in California, people do go out of their way to avoid probate. Compared to California or some other states, Pennsylvania is known as a fairly easy probate state. There is a waiting period. You file that will, you start the process. The creditors have a year to show up and say we're owed money by the person who passed away. But as far as the fees and the delay, in the scheme of things, compared to other states, through my research, Pennsylvania is not that bad. And as far as fees go, there's a sliding scale for what an attorney can charge. I'm told some states, and you might know this better than I, some states you're not even allowed to do it yourself as the family member. You must hire a lawyer. In Pennsylvania, I think they prefer that you do because they don't want the courts clogged up with people
Right.
essentially practicing law. But you could do it yourself. But it's complicated enough that it's worthwhile to hire an attorney, and then there's a sliding scale so attorneys aren't gouging estates, but they're also getting paid enough to make it worthwhile.
Yeah.
That's generally how it goes.
So in the 1 year waiting period, let's just use a simple example. Let's say the only probate asset is the decedent's home. Everything else, beneficiary designation, IRA, life insurance. So during that 1 year period, can the home be sold or transferred to the heirs, or does the transfer have to wait until the 1 year period expires?
No, it can be sold for sure, and you might need to pay bills if there
Yeah,
are no financial accounts. But you do have to wait out the 1 year before you
before
follow
you
the
make the
steps.
distribution.
Correct.
Yeah.
I mean, so
Okay.
so it can be exactly. So, that's hard. I mean, so if even retirement accounts are in the mix of our inheritance tax, sure, we could make that distribution or the life insurance pretty quickly. But what if there's no money to pay the inheritance tax or to pay the creditors? You don't want to be chasing people to claw back money for bills. So it's really, even with these different channels that things go through, probate and non-probate, it's good to do it in a global way, and that's where attorneys tend to get it. They see the big picture, and can make sure that nothing's missed, and nobody is getting a nasty letter later that they're owed taxes or something like that.
Right. Yeah, the inheritance tax. What assets of a decedent are subject to the tax? Does that include IRAs or life insurance or all that, really?
Everything except life insurance. Life
Okay.
insurance is not taxed, but everything else. And of course, if it's going to a spouse, it's a tax rate of zero, so that's
Okay.
not a concern. But yes, everything except life insurance.
Yeah. Okay. So those children really have to take a distribution from their inherited IRA in order to pay the tax. Is that does
And
it
and
how
and that's the
how does that
thing.
work?
The inheritance tax is technically the responsibility of the person receiving it. Now,
Right.
every single attorney writes a will, for example, that no, pay these taxes off the top of, with the estate, and then just distribute what's left to the children. But right, if they're getting money straight from a life insurance policy, you want to have that included in all the work you're doing so that you can cover the taxes, and then they get the money. You don't want them to have to independently be responsible for paying that tax because it might not get done right.
Yeah. Yep. One issue, it's in the back of my mind. You can tell me I'm crazy if you want to, but I vaguely remember seeing some discussions in Pennsylvania about you need to be really careful about transferring your home to a revocable living trust because if the trust doesn't have these particular provisions, you lose the homestead exemption or there's some adverse consequence. And it had to do something with who were the contingent beneficiaries of the trust, something like that. Does that jog
It,
up?
it, it rings a bell. Yeah. So there's two. First of all, the homestead exemption saves you a couple $100 on your property taxes
Right.
once a year. And there's two requirements. Number one, it has to be your primary residence. So you want to bend over backwards in the trust saying this will continue to be my primary residence. But the other factor is it has to be owned by you as a natural person, not by a trust, not by an LLC. So you are likely to lose the homestead exemption on your property taxes. But the other issue you may be thinking of is like anything else. When I talked to, we were talking about a tax on your estate, a transfer of wealth from your estate, a gift tax, a transfer of wealth from you to another person during your life. It's always the government just getting a piece of the action of these transfers. Well, don't you know it? There is one when anytime you transfer real estate, that's called the realty transfer tax.
That's what it
And
was.
that's what it is because it's a bizarre issue because what it says is if you could normally just transfer property straight to your child and that's not subject to the realty transfer tax, then you can put it into a trust that's not subject to the realty transfer tax if the beneficiary is your child. But as soon as you go saying, which is responsible estate planning, I think, what if my child dies and there's nobody
Sure.
else in the family? Then I want it to go to my cousin or my niece or my nephew. Now you have to pay 2% of the value of your property in realty transfer tax. That's more than you're going to pay me to draft the trust in the first place. That's a lot of money. So you have to be very careful about that. And then once that whole issue, once the deed is recorded and they say, fine, no realty transfer tax, then either amend your trust or exercise a power of appointment to amend your trust. The fact that we have to play these games is kind of silly, but that's the law.
Okay, so the original trust says it goes to the kids, and then you amend it or restate it later to provide for some of these reasonable contingencies. Is that what you're saying?
Correct. I mean,
Yeah,
if necessary. I mean, so if there's a family where that's a real possibility, or if they don't come into me when the child is actually deceased, and
right.
then we're going to have problems. So we have to consider: do we restate the trust? Do we exercise a power of appointment? What do we do to provide for a contingency that would otherwise be taxed pretty heavily?
Yep. Well, I want to move over because we talked before we even started, and you mentioned the elder law. And by the way, do you kind of consider elder law and long-term care Medicaid eligibility planning? Is that kind of the same thing when you say elder law?
I think so. I think that's what there's no definition. I've spoken to elder law attorneys who practice in Westchester County, New York, probably one of the highest net worth zip codes in the country. And I said, really, how much Medicaid work are you doing? And they said, oh, very little. But they have another definition of elder law. When I say that, really to me, that means middle class estate planning and asset protection. And if I look at someone's finances and I look at them having a 1 in 3 chance of having dementia and a close to 70% chance of needing long-term care in their lifetime, well, that's going to get in the way of their goal to leave property in their will. So we have to think about asset protection and we have to think about the long-term care system. So yes, we do build that into most estate plans because we do tend to have a middle class clientele. And so we're anticipating the way Medicaid pays for long-term care. We're building that into the estate plan. And then if the time comes where there is an incapacitating illness, we are doing Medicaid planning when otherwise this family is going to pay between $13,000 and $15,000 every single month.
Yeah, that's a big number. I used to tell a joke in my presentations, but I just realized talking to you, I can't tell it anymore because I used to tell people, hey, you want to make sure that you hire an elder law attorney and not an elderly attorney. And they would all laugh, but I did that joke back when I was in my 30s, and I don't think I can tell that joke anymore. But
Might not be good for business, Paul. Yeah.
So yeah, to me, Medicaid, long-term care Medicaid eligibility planning is kind of fascinating, and maybe I'll try to give a quick definition of it. It's kind of positioning what you own so that in the event you generally need nursing home care in the future, as Patrick said, $13,000 a month, maybe more. If you position what you have appropriately and title things appropriately, more on that later, then you're not subject to losing everything that you've saved for during your lifetime. You can qualify for federal and state Medicaid programs and really preserve those assets for your family. It's a fascinating field. I've helped a lot of people with it in my state of Louisiana over the years. And I know I want to see where you stand in this kind of ethical dilemma, even though it's the federal and state lawmakers who make the law and say, as long as you follow the rules, you can do this. And so, but then there's always that question, even though you can do it, should you do it? So a simple example is if somebody were to come to me and they had a $10 million estate and they said, Paul, we don't want to lose our assets if we go into the nursing home. But we'd really probably have to have a conversation with those people about, do you really want to take the action that you need to take, and in many cases lose control over the significant portion of what you have in an effort to try to have only $2,000 or less in your name and qualify for the long-term care that the government provides to the indigent. If somebody has $10 million, and that's a pretty extreme example, I'm usually like, look, you're fortunate that you have that. And so maybe you should consider not engaging in this long-term care Medicaid eligibility planning. Be fortunate that you have it, plan to use it if you need it to get the kind of care that you want and deserve, and not the kind of care that the government provides to people who have less than $2,000 in their name. Most people who are wealthy, they kind of get it once they have that conversation. So give me your thoughts on just this. Who's Medicaid planning right for? Who may it be inappropriate for? And yes, our clients can make their decisions. Our job to help them make informed decisions. Ultimately, it's the people who are taking the action that make the decision. But just love to hear your thoughts on when it's appropriate and when it may not be.
Right. I think we're mostly on the same page there. One thing I might disagree with is when you say what the government will pay for with Medicaid, there is this sort of persisting misconception that if I go on Medicaid, I'm going to be in some dungeon of a nursing home. And at least where I am, they all take Medicaid. The really, really nice
Yeah.
places and the places that I steer my clients away from, they all take Medicaid. That why is one place they provide outstanding care and the facility is well cared for? Because it's locally owned, as opposed to the one owned by a parent company who knows where, and they're trying to squeeze all the money out of it. Now, Medicaid does put financial constraints on the industry, but that's more on the state legislature and how much money are they putting into the Medicaid program. But in general, what are we talking about here? I mean, for starters, if anybody's listening to this and they think, well, wait a second, Medicaid, what if I have Part A and Part B of Medicare and all of that? Medicare pays for your acute care, but not your long-term care. So if you have advanced dementia, if you have a stroke, if you have limited mobility, just getting through your day every day, and you need nursing home care, Medicare is not going to pay for any of that, or very little of it. So there's only a few ways to pay for it. Now, do I steer people towards Medicaid? I don't steer them. I mean, if you said, the person with $8-10 million comes in and let's say they're facing the spouse it needs nursing home care right now, and they want to talk about Medicaid, I would say it doesn't even work for you because of the way that we shift the assets from both of them to just the healthy spouse at home. There's a process we have to go through, and it takes time. And the more money there is, it's going to take a very long time. So what is the likely longevity of somebody? And in the meantime, even though this is a legal tool available to you, I think it's my ethical duty to tell you a financial advisor could be working wonders with this money. You're going to have total control of the money. there's other avenues. So I don't even think it works for people over at least about 1.2 million. It starts to really break down,
Right.
especially if the people are older. Now, if you're talking about the ethics of planning well in advance, you can do trust planning where you get property, money, accounts, everything except your retirement accounts out of your name. And they tell me they have $10 million. I'm telling them it is a legal tool that is available to you. That's my ethical duty. If I have to put all of the legal tools on the table for a client, but I'm also again going to tell them you can you can buy long-term care insurance, you can self-fund care, and then you're going to have total access to your money. Whereas if we put it into a trust, if we put all this land into a trust, there's only so much you can do with it. You're really making things less flexible. And I think what you're talking about, the luxury of having that kind of money, means you have a little more freedom and flexibility, and you're going to get to stay home when the poor soul who can't afford a home care agency to come into their home, they put their thumb on the side of the scale of a nursing home because they can get broke and Medicaid will pay for all their care. So yeah, I'm with you. I mean, there's what's legal and there's what's practical and what really makes sense.
Yeah, and I'm all for people making their informed decisions. I do want to use this platform to let people know that there are some challenges with Medicaid eligibility planning. I was asking Patrick before we started, what's the rule in Pennsylvania with IRAs? For many people these days, their largest financial asset is their traditional IRA. They worked at a company for many years, had their 401k, they retired, they rolled their 401k over into their traditional IRA, and it may be worth $1 million or more or less. And so some people mistakenly believe, well, I can just take that IRA and I can put it in my kids' names, or I can put it in a irrevocable trust that I hear about. And that way that IRA will be protected. In my state of Louisiana, the IRA is accountable resource for either spouse. Patrick was letting me know that it's counted for purposes of at least what I call the institutionalized spouse,
Right.
and if they own it. But a lot of people come in. I want to position these assets so that I won't have to consume them if I go into a nursing home. But really, the only way to get an IRA out of your name is to pull the money out of the IRA. And if it was a traditional IRA, now you're incurring, if it was $1 million IRA, likely hundreds of thousands of dollars of income tax. And then at best, you can transfer the after tax proceeds into a trust or some other vehicle. And so once people find out, that's kind of the first discussion we have with people. And once I find that once they find that out, if they can swing it and they'll just say, you know what, Medicaid planning may not be for us. I have my IRA. I'd like to keep it in my IRA. I was planning on taking just the required distributions. And so let's just leave it like it is, and I'll privately pay if I need that care in the future. So do you find those kind of IRA discussions similar with your clients up there in Pennsylvania?
It's a very common question because you're right. That's where people are, they were incentivized. They were given a reason, tax reason to save money that way. But then when I tell them about the threat of long-term care and the cost, they say, well, you said we can put our house or a life insurance policy into a trust. Why don't we just put the IRA into a trust? It's exactly what you just said. You have to take the money out. You're going to have income tax. Then you're going to put whatever's left in there. What's the alternative? You keep it in your name, and at least in Pennsylvania, if you're the healthy spouse at home, your IRA is completely off the table. It's not, doesn't come under consideration. But if you're the one who needs Medicaid, you have to liquidate it. You take the money out, you take the tax hit, and then you get as much of that money to, let's say, the kids as possible. And even there, if you're trying to gift to kids well in advance, if you're trying to gift in the moment of going on to Medicaid, there's a penalty for gifting under the Medicaid rules. So there you're going to lose about half the money. So there's no great answer. The best answer is if you're, be married and just transfer all the money to your spouse. We can save 100% of money for spouses, but we have to liquidate the one going into the nursing home, their IRA, and get the money over to the spouse. So it's a cumbersome process any way you look at it.
Yeah, some people I'll explain the rule about the IRA and how difficult it is to get those assets out of their name for Medicaid purposes. And I hesitate to explain the rule because they're like, darn, I wish I didn't have this IRA. And I'm like, no, 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 it's not. So before I have the IRA conversation, I kind of prep them because I know they're not going to like what I'm about to tell them. And so I'll say, look, we're about to have a discussion about your IRA. Would you prefer that I give you the blunt version or the sugar-coated version? And then they're always like, well, give it to me blunt. And it kind of gives me permission to tell them the sometimes bad news about how it's not so easy to protect the IRA if it's in their name. So yeah, that and like I said earlier, it's for many people, it's their single largest asset. You know, they may have the $500,000 home and a couple of $100,000 in their savings account, maybe a brokerage account that's easy to transfer a few $100,000. Then their IRA is worth $1 million or maybe more. And then they're well, let's just transfer the other things, but leave the IRA like it is. And then brings up a whole nother discussion. Are you really doing any good? Because ideal Medicaid planning is getting it all out of your name, not leaving a $1 million IRA and getting the rest of it out of your name. So lots of issues there. What kind of what do you see in your practice? Kind of a percentage roughly of the people that you talk to, that's their number one concern versus the people who don't have the concern and they just want to make sure that they make things easy for their family, avoid taxes, all the traditional estate planning issues. What are you seeing up there?
I mean, I think as much education as I try to do to bring all of these complicated issues together in seminars and webinars, really at the end of the day, it's the latter. People say, look, how do I just keep as much money in the family, but really I just don't want to be a burden on my kids. Okay, well, uh, we can do that. I mean, it's incapacity planning, it's some measure of asset protection, and it's a distribution plan. Do we do trust planning? Sure, because sort of piggybacking on what you were just saying, even if they, and I'll say, where I live, there are some people who have the most of their wealth in land. So especially in some of the more rural areas you can get to in a hurry from here, they have, you would think they're wealthy, but they don't have much to live on. And so protecting what has been in the family, maybe family land. We had a recent case, 200 years this land has been in the family, and both parents have advanced Alzheimer's, not a lot of cash. How do you keep the land in the family? That's really important to them. So we sort of meet them where they are. But even if we can protect the home and then come up with a plan to transfer retirement accounts in a crisis, we tell them there's planning you do now and there's planning you do in that health crisis, and we're going to set you up well in case there's a crisis, and then we'll be there for you. But we try to hit it early, anticipating down the road. I mean, we say
Yeah.
we're building a shield to
Yeah.
protect you from predictable challenges.
Yeah. And a couple of quick questions about your business. I know when COVID hit, I kind of came home, started doing a lot of Zoom meetings, got a little bit spoiled with it, got a lot spoiled with it. Love the Zoom aspect of my practice. Just kind of general layout. Are you still seeing a lot of people in the office? Or do you do Zoom meetings? Do you help people who are geographically maybe not around the corner from you that force the Zoom video meetings? What's your business look like from that perspective?
Especially, I'm glad you mentioned COVID, because I had a bit of terror during COVID, thinking, well, if we have older clients, they're not going to know how to use Zoom. They're not going to want to leave their homes and come into the office.
Right.
They were the ones who were most emphatic about coming into the office. They wanted to be face to face. They want to see that they can trust you. They also wanted to take the mask off. I mean, it was so we've always been heavy on seeing people in person. Do we make Zoom available? Of course. And I mean, even just earlier today is a good example where some people, maybe mom is in the room with one supportive adult son, and then the one who lives in Nebraska is on Zoom and
Right.
on the wall. So we make it available as much as possible. But I find that most people really do want to be face to face.
Yeah, the Zoom is great when you have people in different geographic areas. I use it a lot on the probate or trust administration side when you have children who are, yeah, in different states all over the country. So it's really convenient for that. I love Zoom. You know, you get to see everybody. You can put things up on the screen. If you say, you know, a meeting's at 1 o'clock, nobody's going to show up at 12:30 or 1:30.
Right,
So
right.
I've got a little
One
bit
thing
spoiled with that.
I'm curious though, Paul, how this works in Louisiana, because one thing that I was hoping was that we could start to do things remotely, like notarizing estate plans. In some states, I think that remote notarization went without any hitch. It was allowed. In Pennsylvania, they said, well, you have to use a preferred provider, and that process was clunky, terrible customer service. And now we're finding the courts won't even honor what was remotely notarized when we're trying to
Yeah.
do estate planning or we're trying to administer an estate. So we're still learning the lessons from COVID, but that's one where there's a lot of room for improvement in Pennsylvania.
Yeah, I think there's a lot of improvement everywhere. I think the requirements necessary to accomplish some type of electronic signature on an estate planning document or a video, something done through video. It's just so restrictive. I don't know of any estate planning lawyers who routinely use their state statutes to enable people to handle signings through video or electronically. I think it's just they're so cumbersome. As far as I know, everybody just still does it with the old wet signatures and the notary and the witnesses. And so, but it'll be interesting to see what happens. I think we're a little bit behind the rest of the financial world because I know that like I mentioned, many people their largest financial asset is their IRA, and they can go online and change their beneficiaries with certain brokerage firms and click of a button, they've changed their beneficiary designations. But if someone wants to leave their, you know, 17 shares of Apple stock to someone, then they've got to hire a lawyer, get all the paperwork done, follow all the formalities, notary, witnesses, and all of that. So it's
Right.
going to be interesting to see what happens over the next couple of decades.
Agreed.
All right. So maybe one more question. You mentioned your seminars and webinars. So just kind of tell the public what that looks like in your area. What are you doing? Just I don't want to know your secret sauce. Well, yeah, maybe I do want to know it, but just at a high level, what are you doing as far as educating your community on estate planning?
Well, I think the whole purpose of the wonderful videos you do is to recognize that some of these concepts are not as obvious to people as we might assume they are. And so there's room for teaching, and people really appreciate it. So, as much as possible, I send out mailers and people show up, and I have waiting lists in the library or the municipal building. And I'll go and I'll teach people what they need to know about estate planning and asset protection and these long-term care concepts. On our website, there's a tab where people can sign up for webinars where I'm doing the same thing for people who would prefer to take it in from the comfort of their own home, and they can ask questions through a chat. And it seems to be very well received. You know, our colleagues who practice criminal defense can't really do proactive education because
Right.
nobody's planning on getting arrested. You know, so for them, that's why you see billboards. It's just top of mind. But for us, we can go out and improve people's lives even before they become a client. And maybe they never become a client, but a lot of them do.
Yeah, and I don't know of a field that's set up better for educating the public than estate planning because we know everybody needs it, everybody wants it. There's a lot of myths out there, there's a lot of misconceptions. And so it seems like people really soak up that education. So that's fantastic.
Yeah,
All right.
and just real quickly, I want to say that I think the next frontier is, you know, we do all this great planning, and then everything we're planning for happens. So somebody has a stroke, they're incapacitated, somebody's got to use a power of attorney, and the adult child has no idea where mom and dad have money. They have no idea what to do with the power of attorney. So we've set the client up well, but I think we could do better with focusing education on everybody else who's going to be the end user of the plan.
Sure.
So yeah, there's always room for improvement.
Yep. Fantastic. All right. Anything that I didn't ask you about that you feel like would be appropriate to share on something like this, Patrick, before I let you
No,
go?
I mean, if people want to find more resources for education, our website is keystoneelderlaw.com, and we have articles and not anywhere near as many videos as you have, Paul, but some videos, and we do our best to keep up.
Where'd you come up with the Keystone name?
I didn't, originally the firm was founded by somebody else and I was the succession plan, but we are the Keystone State. So
Okay.
it has that double entendre. We want to be the keystone holding the whole plan together for your family, but we're the Keystone State in Pennsylvania.
Fantastic. All right. Well, thanks so much.